Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's episode of Business is More Exciting Than Any Game. Today I'm going to be asking and hopefully answering the question, what is the most important provision to have in your foundational or beginning agreement among business owners? If you have a business that has more than one owner, and you have yourself and maybe a co-owner or multiple co-owners, you need to have an agreement among yourselves, and what is the most important key provision to have in that agreement. All right, we're going to be talking about that, but let me just cut through the suspense and let you know the most important provision to have in your foundational agreement is a buy-sell provision. What is a buy-sell provision? A buy-sell provision is a provision that provides for what happens in the event some life event occurs that would make you want to either sell or buy the interest of one of your co-owners. For example, what happens if you own a business with another person and that person dies? Who gets his business interest, his or her business interest? What happens to that business interest? If you don't have a buy-sell provision and one of your co-owners dies, then you could very well find yourself in a situation where your business is going to have a new owner, which is going to be a beneficiary of the deceased co-owner, one of his children, one of her children, someone that you didn't plan on doing business with. That's the reason why you want to have a buy-sell agreement, is because you don't want to have some life event occur that introduces someone that you did not expect or want to have as a co-owner of your business. At the same time, if you are a co-owner and you die, you're going to want to make sure that your interest is purchased at a fair price by the other co-owners who are left in the business for the benefit of your estate and for your family, your beneficiaries. And so both sides really want and need a buy-sell agreement. So that's just an example. There are many, many other examples of when you would want to have a buy-sell agreement or a buy-sell provision to come into play. So let's just talk about what are the key components of a great buy-sell provision in your agreement among co-owners. The first is, what are the triggering events? What are the events that would happen that would bring the buy-sell provision into application, or when would it come into play? So I just mentioned one of the triggering events: death of one of the co-owners. Another would be divorce of one of the co-owners. If you don't have a buy-sell provision and one of the co-owners gets a divorce, you may find yourself doing business with the ex-spouse of one of your co-owners. Death, divorce, retirement, bankruptcy. You could ceasing to be employed by the company. There are a number of triggering events that you would want to cover in your buy-sell provision. The second key component of a good buy-sell provision, or a great buy-sell provision, is a determination of what is the value of the interest that's then going to be acquired by the remaining owners or by the business itself. In other words, what is the price that the owner that is leaving the company, either through death, divorce, retirement, bankruptcy, what is the price that person is going to get for their business interest? And so there are a number of ways you can determine it. Some are good, some are better than others, some are not so good. One way, a simple way, which is not a very good way, is to have a set dollar amount for the business interest. So you have an agreement, you say, you have a co-owner, and you say each of our interests is worth X dollars, and that's the amount that's going to get paid in the event of a triggering event like death, divorce, whatever. The reason that's a bad provision is because while that may be a price that you've agreed on is a good, fair price today, it's not necessarily, and probably won't be, a good, fair price next week, next month, next year, 10 years down the road. And so just setting a dollar price in a buy-sell agreement is not a great idea. Another way of setting the price is through a formula, an objective formula, like, for example, so many times the past year's net earnings, or so many times EBITDA of the company. That is a better way of doing things, but again, that's an item that you want to discuss and negotiate with your co-owners, because it may be that over time you may decide that that's not really a reflection on what the value of the company is. There may be some intangibles that come into play in the valuation of your company that you just can't, that aren't reflected by a strictly objective formula valuation. But it's better than a set dollar amount for sure, and you do see formula valuations in buy-sell agreements. But again, that's something for you to discuss with your other co-owners. The third and probably most common approach, and one that I think is probably the best approach, is to have a provision that allows for the valuation of the company or the owner's interest who's going to be purchased, having that valuation determined by appraisal. And you can have a number of ways of dealing with that. Either the owners each select one appraiser, and the two appraisers work together to come up with an appraisal, or they take some kind of average of the appraisals. But probably a more common approach is that each party decides on, or elects or selects one appraiser, and those two appraisers select a third appraiser that would make the determination. But however you decide to provide for a valuation, an appraisal which would occur at the time of the triggering event is a great way of coming up with a value. So determining what are the trigger events, that's key. Determining how valuation is to be made, that's key. And the last major key component of a good buy-sell provision is how is the purchase price going to be paid and funded. If the triggering event is death, it's common to have the buy-sell purchase price funded by life insurance. Each owner can have life insurance, and the payments of that life insurance can go in to the pot, so to speak, to provide for the funding of a buy-sell provision. If the trigger is something other than death, then life insurance obviously is not going to work. So if you have a trigger that's divorce or retirement or bankruptcy, you're going to have to come up with some other mechanism for funding. And it may be that simply that you have a provision that allows for the purchasing co-owner or co-owners to just pay the purchase price over some period of time. And if you do, whatever interest rate might be charged on the payments over time, that would again be something to be discussed and negotiated. So we've talked about why you want to have a buy-sell provision, why it really is, I think, the most important provision to have in your foundational agreement among your co-owners, and what the key components of a great buy-sell provision are. So I hope that helps, and we'll see you next time on Business is More Exciting Than Any Game.